We are here today on final trial for a divorce without children, and the only two issues that are before the court is the division of personal property. There is no real property, and then the request for attorney's fees, right?
Yes, Your Honor.
All right. Okay. And prior to going on the record, there was a stipulation of some exhibits, and they will be admitted at this time. So petitioners exhibits 1 through 5 are admitted, and the respondent does not have any exhibits to tender to the court. You all are set at 15 minutes aside. That will include any opening and closing statements, should you all choose to make one. You're absolutely free to waive those. Mr. Ford, you're representing yourself. So
Yes, ma'am.
so you're subject to the same rules of evidence just as an attorney is. If you hear an objection made while you're speaking, just stop speaking, allow the objection to be made for me to make a ruling on it. And if you hear me say overruled, that means you may continue to speak. If you
Oh,
hear
yes.
me say sustained, that means you have to stop speaking. You have to move on to whatever question that you're asking. If you're asking Ms. Flanagan a question, or if you're testifying for yourself, okay?
Yes, ma'am.
All right. Attorney Evans, would you like to make an opening statement at this time?
Yes, briefly, Your Honor.
Go ahead.
As the court has noted, there is minimal issues of concern today. My client has a couple separate property items that she is asking the court to confirm. With regard to community property, we are fine with each party or asking the court that a just and right division be that each party keep what's in his or her own name. The majority of the beneficial assets are in the name of Mr. Ford, but my client is in agreement to waive any interest to them. And lastly, Your Honor, because the issues are so limited, we are asking for attorney's fees, just because we believe that we didn't have to, go through all this to be here today for the court to decide these things.
Okay. Thank you. Mr. Ford, would you like to make an opening statement?
Yes, ma'am. I don't want anything. I'm not asking anything. I have really no assets or nothing. I just want to walk away what I had the same way on the first petition that she said in the beginning. She want to walk away what she has. The only thing that I ask is I don't want to pay for attorney fees because I couldn't afford my own attorney, and I didn't ask for the divorce. I didn't want the divorce. I still want to work on my marriage. But I can't stop somebody do what they want to do, and I have to respect it. So yes, ma'am. So also with the 6600, also that is a civil case matter, and so that's not doing with the marriage. That was before the marriage. So yes, ma'am. That's all I have to say.
Thank you. All right. Attorney Evans, you may call your first witness.
I call Hersey Ford, Your Honor.
Okay.
Mr. Ford, from that opening statement, just to clarify, since we have such limited time today, so you understand that my client is asking for confirmation for her separate property items, being the house she inherited, her business, and her vehicle.
Yes, ma'am.
Okay, and you're not contesting any of that.
Yes, ma'am. I don't want nothing.
Okay. And then with regard to the community property, you also stated that you're fine with each of you keeping the assets as well as the liabilities that are in each of your own name.
Uh, yes, ma'am. When she came in and stuff, like she go away, and what I have, I just go my way. Yes, ma'am.
Well, actually, too, though, what was accumulated or accrued during the marriage, you're also still in agreement that what's in her name will be assigned to her or awarded to her, and what's in your name will be assigned or awarded to you.
Well, what you mean by that?
Anything that was accrued or purchased during the marriage, which I don't think is much. I think you have some retirement that accrued during the marriage. And so I'm just confirming for the court that you're fine with that being remaining in your name, and then anything that Tatiana may have had or acquired remaining in her name.
Only thing I'm saying, ma'am, is whatever she has, she can have, and whatever I have came in, I'm just going. Yes, ma'am. So it's hers, it's hers. I didn't marry her to take. I didn't do that. So she can have what she has.
Okay. And then with regard to the $5,600, that was, so I mean, just to clarify for the court, you borrowed 6,000 from Tatiana's grandmother for, I think, wedding costs.
Yes, that was before the marriage. She had gave it to us. Yes, ma'am. That is a civil case matter. That has nothing to do with the marriage. That was
Well,
before.
I understand your position on that, but just to clarify the facts, so Tatiana's grandma gave you guys $6,000 for wedding expenses, correct?
Yes, something I did not want at the time, and I previously said I didn't want it.
Okay, Mr. Ford, I'm gonna ask you to just kind of respond to the questions that I'm asking because time is limited. You'll have your opportunity. Um,
Yes, ma'am.
okay. And then since that time, you were supposed to make payments to her grandmother, Miss Ora Flanagan. Is that correct?
No, it was no time limit. So no, ma'am. There was no time limit.
I didn't say anything about a time limit, but you were supposed to be making continuous payments to Miss
It
Ora.
was a gift. It was a gift. So it was a gift to me and Tatiana.
So your position is that she didn't loan you the money the way you just testified.
Only thing I'm saying is, ma'am, when she said whenever you have time, help back. And then the situation when we got married, when we got the house, Miss Flanagan did say, "Don't worry about taking care of the mortgage." And then when me and my wife decided to split up, that's what she wanted, and I didn't want my divorce. That's when Miss Flanagan came to me and said she wanted the money back after she told me I could put it towards the mortgage for the house. And I said, yes, ma'am.
Okay. I passed the witness, Your Honor.
All right. Mr. Ford, so at this time, because like I said, you are representing yourself, you can either testify of what you want me to know right now, or you can wait until it's your what's called case in chief, and that's when you will present your case and then speak and tell me what it is that you would like.
Yes, ma'am. Either or. I'm just, I'm just here. Yes, ma'am.
Okay. So she can go ahead and finish her case, and then once she finishes her case in chief, then you can tell me what you want me to know, okay?
Yes, ma'am.
Okay. Attorney Evans, you may call your next witness.
I call Miss Tatiana Flanagan.
Okay.
Tatiana, and you were married or are married to Mr. Hersey Ford.
Yes, ma'am.
When did you guys get married?
We got married May 15th, 2024. No,
Okay,
March. I'm sorry. March 15th, 2024.
and you guys, have you resided in Dallas County for the past 3 months before filing for the divorce?
Yes, ma'am.
And did you reside in the state of Texas for 6 months before filing the divorce?
Yes, ma'am.
Is that also true for Mr. Ford?
Yes, ma'am.
And the marriage has become insupportable beyond reconciliation?
Yes, ma'am.
And with regard to the separate property that's been remedied, the community property, it is your wish that each of you keep what's in your own name, correct?
Yes, ma'am.
Now, if you could tell the court a little bit about the $6,000 that was loaned from your grandmother, who's with you today, correct?
Yes, yes, she is. My great grandmother is with me.
Okay.
Okay, so he and I had an agreement that we would pay for our wedding. So I would pay my portion, he would pay his. I paid my portion. He was unable to pay all of his. So he took a loan of $6,000 from my great grandmother. He was supposed to pay it back. He paid $400 via Zelle back to her. She's reached out to him several times, just reminding him to pay it back. And every single time he would say that he's going to pay it back. He's going to keep on paying it back. He did not do that. I think the last time they reached out, it was September of 2025. So on December 25th, 2025, I paid my great grandmother back that money in cash because she needs it. She needs her money. She has her own medical conditions and things of that nature. And I wanted to ensure that she had it back, being that she loaned it to him for our wedding.
And you're now asking the court to order Mr. Ford to reimburse you for that amount?
Yes, ma'am.
Totaling the $5,600?
Yes.
In addition to that, do you believe that an attorney was necessary for this case?
Yes, ma'am. Absolutely.
What made me necessary or an attorney necessary?
From May of 2025 to the present, Mr. Ford would say that he would sign my divorce papers, especially considering I wasn't asking for anything. He said he would sign it, and then he wouldn't. He wanted me to meet him places. He wanted me to go to dinner, do this, do that, and I just did not feel safe. I didn't feel comfortable to do that. He provided an answer to my petition. He didn't contest anything, which he admitted that. I've had to block over 30 different numbers. He's shown up to my home, and furthermore, we have a history of domestic violence. He is literally put his hands around my neck. He's punched holes in my walls, punched holes in my doors, jumped on my car. He's threatened to commit suicide right in front of me just because I wanted to leave.
And it's because of
Or
this
because I wasn't doing what he wanted me to do. So I needed an attorney, yes.
and it's because of this that you didn't feel comfortable adhering to his commands to meet in this place or that place, etc.
Correct.
Even after I came on, or actually, I guess throughout the entire divorce proceeding, has Mr. Ford been cooperative, or have you had to incur additional attorney's fees due to his non-cooperation?
We've had to incur additional attorney's fees because he refused to sign.
This is with the second trial setting in this case?
Yes.
And we've also been set for mediation, or attempted to set for mediation, a couple times without his cooperation, correct?
That's correct.
When we did ultimately go to mediation, was it clear then that that was also a step that wasn't really necessary? His desire was just to drag this out.
That is also correct.
I pass the witness, Your Honor.
All right. You may call your next witness.
I call Aura Flanagan.
Okay.
Miss Flanagan, there was some contradictory statements made by Mr. Ford. Can you clarify whether your intent was to be paid back the $6,000 or whether it was a gift?
Yes, no, it wasn't a gift. Hershey called me, explained his situation, and asked me if I could loan him $6,000. I said yes, I was willing to do that. The agreement was between he and I that he would pay $100 monthly if he could. I did tell him whenever he could, as long as he paid it. He did agree to do this. The last hour. I'm sorry, you have a question?
No, yeah, I was just going to clarify. So throughout that, over a year period, he had only paid $400.
Yes, I have it. He Zelled it to me, so I do have documentation of that, which I had told him that also that I was keeping records of it.
And did he at some point become non-responsive to your inquiries for the money to be paid back?
Well, the last I texted him while we were sitting in church. I have it on my phone. I believe that was. I have it on my phone. We were in church, and I sent it to him, a text to him, and
you don't need the message. Your testimony.
Okay. He agreed, and he didn't answer while we were in church, but once we got on the parking lot, he approached me, and we embraced and what have you. And he told me, I said, "Did you get my message?" He said, "Yes." He said, "Grandmama, I would take care of that."
Okay.
And that was the last we heard.
And ultimately, he did not take care of that balance, correct?
No, he hasn't.
And in December of last year, Tatiana went ahead and paid you so that you could be made whole from that?
Yes, and she gave it to me for Christmas, as a Christmas present, I guess. Yes.
Okay, and that was for the $5,600, the remaining balance, correct?
She gave me $5,400. $5,500. I still have it.
No. Okay, it should be 5,600. Is that accurate?
Yes.
Okay, I pass the witness, Your Honor.
All right, you may call your next witness.
Nothing further from this side, Judge.
Okay. So you are raised, and Mr. Ford,
I'm sorry, Judge. I do need to testify as to attorney's fees, which you have the document in front of you.
Okay.
I am a family law attorney in Dallas, Texas. I have practiced for over 5 years now. I charge a billable rate of $350 per hour. I do believe this rate to be comparable, fair, and reasonable. In this case, the total, well, we capped it at 5,000. It did go a little bit over, but we did a professional courtesy not to charge the client for it. We do believe that these fees were unnecessary in this case. As you can see, not only are there limited assets, but within those limited assets, both parties are in full agreement to keep what's in his or her own name. And so my client is asking that Mr. Ford be responsible for my attorney's fees.
Thank you. Mr. Ford, this is now your opportunity to tell me whatever it is you want me to know based on the questions that you were asked, your side of it,
Yes,
whatever.
ma'am. Yes, ma'am. Yes, Your Honor. I'm gonna make it fair because I'm at 10% on my phone.
Hold on one
So-
second. You're kind of muffled.
Oh, yes, ma'am. I'm at 10%, so I'm gonna go ahead and talk to my phone before it try to cut off.
Can you charge the phone because we have to finish the trial?
I try. I'm out and about at work, and my station is about 30 minutes on the other side of town, and I had to get off the train for the Zoom meeting.
Okay.
I can try to ask somebody for an iPhone charge. I don't know.
Well, just start talking. Just start talking.
Okay, yes, ma'am. The situation with Miss Flanagan when she said that I had called her, that was false. We was at the wedding place that day when we all got in a circle, and I remember informing her that I do not want to take it because I just got out of the hospital. My health is not 100%. They had cut hours from work, and I'm not going to be able to get that to you. She told me that Tatiana deserved the best of everything. I also told her we can get married at the church for free. She gave it to us as a gift. There's no writing statement saying that I must pay back. There's no receipt. And also, I would like to have a receipt showing that Tatiana paid her grandma back the amount that she says. I would like to also see that, or you can see that, Judge. Also, with the situation of the fees, of her lawyer fees, I could not afford a lawyer. I do not have the money to get a lawyer. I'm in so I feel like to each his own should take care of their own lawyer fees because I did not want the divorce. I did not ask for the divorce. And then we had the time to meet up one day for me to sign the papers. And I said, hey, you can meet me at this time frame. And I was signing, we can go our ways. She told me, no, baby, that's not how it's done. We don't do stuff in your timing. That's not how it's going to work. You have a great day. Goodbye, sweetheart, and hung up in my face. So that's what happened. And then when I came to church, I was trying to ask her again because I used to open her car doors and close it for her. We could have did it then. She didn't want to do none of that. So, I mean, we didn't need no lawyers. We didn't need anything. She wants stuff done on her time, and that's what that she wanted. So I wanted to sign the papers that day. I didn't have no ill will, no issues, and I still have nothing against her and her family. I wish them all the best. So that right there, man, was false. So, like I say, the 5,600 that was something that was given. That's also like a civil case in a matter, and the lawyer fees. That's it, ma'am. That's all. Like I said, I couldn't afford my own lawyer, and we didn't need no lawyers.
Okay, is that all you?
And I don't want nothing.
Okay, is that all you want me to know?
Can you hear me?
Yes.
Yes, but I'm putting the phone to my ear. I'm sorry.
Is that all that you wanted me to know?
Yes, ma'am.
Okay. Attorney.
Like I said, I just want my peace. My soul desires my peace. I wish nothing bad to nobody. I wish everybody well. That's all I'm saying.
Okay.
No hard feelings. Yes, ma'am.
Thank you, Mr. Ford. Attorney Evans.
Yes, Your Honor.
Go ahead.
I mean, I honestly have nothing further from the court, Your Honor. I rest and close.
Okay. All right. I see it says Flanagan on the screen. Did you ever change your name to Ford?
No, ma'am.
Okay. All right. So I will take this under advisement and I will get you all a ruling emailed out. Okay.
Thank you, Your Honor.
Thank you all.
Ma'am.
Thank you.
We're set here today on a motion for new trial filed by you, Attorney Petitioner, on behalf of your client, Mr. Green.
Your Honor, this trial was held on October 30th of 2025 in your court, and there was a final order that was entered on February 24th of 2026. The motion for new trial was filed on or about March 24th of 2026, which makes it timely within that 30-day time frame that we are required to file this. In addition to that, the arguments that are going to be presented to the court today would show that the ruling that was made and entered on February 24th of 2026 is legally and factually insufficient in order for the court to have made a just and right division of the property. And I would like to start my argument presenting the following grounds for that argument, Your Honor.
You may proceed. Oh,
The
is that
first,
part of your opening?
no, Your Honor, I'm done with my opening.
Okay, let me move over to Attorney Mitchell. Would you like to make an opening?
Yes.
Okay, you may proceed, Attorney Patino.
Yes, Your Honor. The first argument I'd like to present to the court has to do with Texas Family Code Section 7.009. There was a claim for constructive and actual fraud on the community in the actual pleadings, and there was a portion of testimony that was presented concerning the tax fraud that Mr. Green was convicted of by the IRS, and he did some prison time, federal prison time for about a year. Well, under the code, the court has to make a specific finding that there was fraud on the actual community in this in order for the court to even consider that in making a just and right division in the divorce proceeding and in the community funds. In this situation, there was not an actual finding in the final decree of divorce of any kind of fraud, even though it was brought up and was implied in the actual proceeding. In order for the court to find that someone has committed fraud upon the community, there has to be a finding that there was a transfer, a gifting, or unaccounted community funds in the actual marriage that was actually made by one person and distributed community funds that were not basically without knowledge or consent of the other spouse. In this situation, none of that occurred because the actual fraud that occurred was with the tax situation for the business that Mr. Green was actually involved in. So the only fraud that occurred was tax fraud directly with the IRS that didn't involve the community or disposing or gifting or transferring of any community assets. In addition to that, the actual lien on the community is just for Mr. Green's portion of his community property division. As the court knows, we have been working on getting the lien release on this, and the IRS is only interested in Mr. Green paying restitution and taking his 30% of what was awarded to him in the divorce. So it didn't affect any of the interest or community portion of Miss Green's in this. So if the court did base their decision on awarding a disproportionate share based on any allegation of fraud, it was not met per the statute I just quoted. My second argument is that per Texas Family Code 7.008, in dividing the estate in a divorce, the court may consider tax obligations. In this situation, I am going to cite Bacchus versus Bacchus. That is BACCUS, and it's 808 Southwest 2nd 694. And this is the appellate court in Beaumont, 1991, and there was no writ on this. And I'm going to quote that case, which says tax consequences stemming from the division of property as well as any unpaid tax liabilities are proper factors to be considered by the court in deriving at a fair and just division and division of community properties. Furthermore, it is reversible error for a court to refuse to consider tax liability particularly when it is a substantial and one of the spouses is without means to pay the obligation. In this situation, the court awarded Mr. Green 30% of the estate. Basically, it was 30% of the equity minus some mortgage payments that were awarded to be deducted. A 2020 BMW vehicle, his personal property, and a non-existent IRA and 401k. There was testimony that the alleged IRA didn't exist. It was a savings account that had money in it that had already been spent. So essentially, Mr. Green was awarded just equity in the marital residence. Ms. Green was awarded the majority of the assets. She was awarded 100% of her 401k, which had over $600,000 in it. She was awarded the rent house, which was valued at probably over $350,000. The values on that are not sure. There wasn't a lot of testimony presented concerning the values of those properties, and the marital residence, which is also worth about $350,000, in addition to vehicles, her personal property, and the majority of any tax liability was awarded to Mr. Green. So in this situation, the court awarded Mr. Green a very little amount of the assets in order to be able to pay the substantial amount of tax debt, which is over close to $2 million in the tax debt that Mr. Green was ordered to pay in restitution for the tax fraud. In addition to that, the $30,000 that what resulted from a joint filing of tax returns that were filed by Mr. Green, including his spouse, in the situation. So the disproportionate share and the division of property gave Mr. Green very little in order to be able to pay the tax liabilities that he has in this court. In addition, there is another case I'd like to cite, Richardson versus Richardson, 424 Southwest 3rd 691, El Paso Appellate Court, 2014, and there was no petition on this one. There's a two-pronged test to determine whether the court abuses discretion. Number one, did the trial court have sufficient information upon which to exercise discretion on a division of property and debt? And two, did the trial court abuse its discretion by making a property division that was manifestly unfair or unjust? In this situation, the court did not have current information on anything that was actually divided. There was not any appraisals done for the marital residence located on Valentino Way, and there was not an appraisal on the rental property that was awarded to Ms. Green. The only thing that was presented was a tax appraisal, property appraisal from 2024 for the Valentino property. The 401k information for Ms. Green was from June of 2025. That was the 401k statement that was presented. The trial was in October of 2025. The inventory and appraisements were entered into court, but without any supporting documentation as to where the values of anything that was listed on there was given. The court actually asked Ms. Green if she had current information on her 401k, which she did not at the time. She only had what was presented to the court, which was a June 2025 statement. In addition to that, there was nothing presented regarding this non-existent IRA or 401k that Mr. Green was awarded. And there was very little that was presenting concerning the debts that were actually awarded to Mr. Green, other than the tax liability and the supposed tax returns that were filed that were never presented to the court, as far as the $30,000 that he was awarded that he had to pay. So the court made decisions on outdated information and insufficient information because very little was presented to the court regarding what was divided. In addition to that, the court awarded that Ms. Green would be reimbursed for mortgage payments from August 2023 to, I believe, October of 2025. And per Texas Family Code Section 3.409. Non-reimbursable claims include living expenses of a spouse. So a mortgage payment would be considered a living expense. So the fact that the court awarded Ms. Green reimbursement on mortgage payments that, one, are considered living expenses, two,
Also, you're out of time.
thank you, Your Honor.
You're welcome. Attorney Mitchell?
Judge, before I begin, I would like to first point out the fact that there has been no findings of fact, and no conclusions of law. So the basis by which this court has made their decision is unclear. And when there are no findings of fact and conclusions of law, the Supreme Court has held that the court must presume the trial court made all findings necessary to support the judgment. Judge, before we had this trial, we both attorneys had to attend an exhibits conference. We entered all of our exhibits into the court's record. We stipulated to which exhibits will be entered and which exhibits will not. Before we actually came to trial, we exchanged both discovery, we exchanged inventories and appraisals, which included all supporting documentation that was necessary, that's required in an inventory and appraisement. So both parties were made very well aware of the size and the amount of community estate, and that was also presented to the court through the evidence that was presented and actually entered into the court's record. Opposing counsel goes on to say that, I'm sorry, I'll go back. Trial courts have been given a wide discretion in determining what is considered a just and right division under the Texas Family Code. Opposing counsel goes on to make these claims that there's been a claim of fraud, and going through the record that's been presented as Exhibit 1 in this case. Fraud was mentioned a total of 16 times throughout this record, and 9 of those times was mentioned by Mr. Green's attorney when he was asking my client about whether or not her putting her mom or using her mom as the beneficiary on her 401k was considered a breach of her fiduciary duty and committing fraud. There has been no findings of fraud. My client did not, her testimony was not based on fraud. There's been no actual finding that this court's made this decision in dividing the community estate based on fraud. Opposing counsel cited Backus v. Backus with regard to the division of property, but the opposing counsel didn't bring up the fact that there are certain Murph factors that have to be considered in determining whether or not there should be an unequal division of the community estate. And that all goes back to whether or not the court made any findings with regard to whether or not there was fraud, and whether or not that support the court's decision. And in this particular case, opposing counsel did not file any findings of fact and conclusions of law. So we have no basis by which this court made their decision. And because we have no basis by which the court made this decision, the court is inclined, in the appellate court, the Supreme Court is inclined to presume that the court made its decision based upon the evidence and the implied findings. So at this point, we're asking the court to just deny this particular motion for new trial. We're asking the court to find that this motion for new trial was frivolous, was not based on any factors, that the evidence was legally and factually sufficient to support the disproportionate division of the property, and to find that the division was just and right in accordance with the Texas Family Code.
Thank you, counsel. Well, Attorney Patino is out of time. Did you need to close, or was that it? Okay. The court will deny the motion for new trial.
Thank you, Your Honor.
Thank you all.
This divorce case begins as what should have been one of the simplest hearings the court could handle. No children, no house to divide, and both spouses agreeing to walk away with whatever is already in their own names. But within minutes, the courtroom shifts from a routine divorce into a deeply emotional battle over broken promises, unpaid money, and the real reason the marriage fell apart. At the center of the dispute is Hershey Ford, a husband representing himself, who tells the judge he never wanted the divorce in the first place. He insists he still wanted to save his marriage and isn't asking for a single dollar from his wife. According to him, he simply wants peace, wants both of them to move on with whatever they already own, and believes each side should pay its own attorney because he couldn't even afford to hire a lawyer himself. But his wife, Tatiana Flanagan, tells a completely different story. She explains that while dividing property isn't the real issue, one financial promise remains unresolved: a $6,000 loan that her great-grandmother gave to Ford before the wedding after he admitted he couldn't afford his share of the wedding expenses. Tatiana says this was never a gift. It was a loan that Ford repeatedly promised to repay. According to her, he only paid back $400, leaving a balance of $5,600, and after months of excuses and broken promises, she personally repaid her elderly great-grandmother out of her own pocket because the money was needed for medical expenses. Ford strongly denies that version of events, insisting the money was actually given as a gift and claiming there was never any written agreement requiring repayment. He argues that the conversation about paying the money back happened only after the marriage began falling apart, and believes that dispute belongs in civil court rather than being part of the divorce. But the financial disagreement is only one piece of the case. The hearing becomes far more emotional when Tatiana explains why she believes Ford should also be ordered to pay her attorney's fees. She tells the judge that this divorce could have ended months earlier if Ford had simply signed the paperwork. Instead, she claims he repeatedly delayed the process, asked her to meet him alone at different locations, and refused to cooperate even though he wasn't contesting any part of the divorce. More disturbing are the allegations she makes about their marriage itself. Tatiana testifies that she no longer felt safe around Ford, accusing him of domestic violence, punching holes in walls and doors, placing his hands around her neck, threatening suicide, and showing up unexpectedly at her home. She explains that because of those incidents, she felt she had no choice but to hire an attorney to protect herself throughout the divorce proceedings. Ford completely rejects those accusations, insisting he never intended to create problems and saying the two could have finalized everything peacefully without lawyers if Tatiana had simply agreed to meet him so he could sign the papers. He repeatedly tells the judge he holds no anger toward his wife or her family and only wants everyone to move on in peace. The courtroom then hears testimony from Tatiana's great-grandmother, who confirms under oath that the $6,000 was absolutely intended as a loan, not a gift, and explains that Ford personally asked to borrow the money, promising to repay it over time. She confirms he only made a few small payments before stopping completely, forcing Tatiana to eventually repay the remaining balance herself. As both sides finish presenting their testimony, it becomes clear that this divorce is no longer about dividing assets but about credibility, whether the money was truly borrowed or gifted, whether Ford intentionally delayed the divorce, and whether his actions forced Tatiana to spend thousands of dollars on legal representation that might otherwise have been unnecessary. Rather than rushing to judgment, the judge carefully reviews the testimony from both sides before announcing that she will take the entire matter under advisement, promising to issue a written ruling later on the disputed $5,600 reimbursement and the request for attorney's fees. In the end, this case becomes a powerful reminder that even when a marriage ends with almost nothing left to divide, unpaid promises, broken trust, and conflicting versions of the truth can turn even the simplest divorce into a courtroom battle where credibility matters more than the property itself.